You check. All right, good morning. I know Robin has gone out to make some more name tags, but I think we can get going in the interim. Welcome back to docket number 250907, 250908, 250909, and 250910, which address petitions filed by Nutmeg Public Access Television Incorporated to assume responsibility for community access operations in various areas across Connecticut. I'm Commissioner Holly Cheeseman. I've been appointed presiding officer for these proceedings, and I'm joined by my incredibly wonderful colleagues, Interim Chair Tom Wheel, Vice Chair David Arconti, Interim Commissioner Jan Beecher, and Interim Commissioner Everett Smith. And here is Robin. Hello. Yeah. We're here today for a scheduling conference in these matters. Before we begin, we'll take appearances from attorneys representing a party or intervener this morning, as well as those not represented by attorneys. And if we, I suppose we can go around, we'll start over there, please. Can you, your mic, make sure your mic is on, please.
Thank you. Joni Wedler, Executive Director of Nutmeg TV.
And Chris Bennett, Director of Technology and Production Services for Nutmeg TV.
Brian Smith with Optimum. Rob Burley, Comcast. Chris Giard, Cox. Lindsay DeRoche with Cox.
Zachary Buster, attorney at Brown Rudnick, appearing on behalf of Cox Communications, Inc. and Optimum Communications, Inc.
Good morning, Commissioners. David Bogan on behalf of Charter Communications as well as Comcast, although today I'm only here on behalf of Charter.
Morning, Commissioners. Mike Chwanek from Charter.
Good morning, Commissioners. Colleen Olson here with Dave Pitney on behalf of Charter.
Any OCC?
Yeah.
Oh, sorry.
Pascal Mpoku, Staff Attorney, OCC.
And Rihanna Ash, Telecom Policy Advisor for OCC.
All right. Are there any other parties or interveners present who would like to be on the record here? All right, seeing none. All right, we're here to discuss the proposed schedules, and we're going to start with 250910. I believe there's discussion going on about a settlement or MOU on that one. Anyway, Nutmeg, we will start with that docket, please. And if you could walk through your proposed schedule, and then I'll allow any other parties to comment on 250910.
Currently, Nutmeg TV is in discussion with Comcast and not part of this proceeding to develop an MOU, Memorandum of Understanding, by April 30th. And so those discussions have already begun, and we're well on our way. Nothing further.
Does anyone else need to weigh in on this one before we proceed to the next?
Yes, thanks, Commissioner. OCC supports the approach being taken by both Comcast and Nutmeg. As you can see in our proposed schedule, we do leave way for us to return back to a full evidentiary process in the hopefully unlikely event that this agreement doesn't yield the proposed results, but would also, as a matter of clarity, like to highlight that within our proposed schedule, the sequencing seems to be off. If you look at the written exceptions due date and the final decisions issued, it says June 7th and June 21st respectively, and we would like the authority to make clarifications when considering putting out the full schedule to make it July 7th and July 21st respectively.
All right, we will note OCC's request and obviously proceed accordingly when we know the outcome of this one.
Thank you, Commissioner.
All right, and I propose that we're just going to conduct these sequentially as opposed to formally adjourning one and moving on to the other if other parties have no objection.
No objection.
I have no objection, although at the risk of overstating the position of the video operators, I think that we believe that there can be a single schedule for the proceedings. So we can proceed as you wish, but I think that the schedule that we're going to propose would be applicable to all of the dockets.
All right, and I know OCC has different views on this, so we will obviously take everyone's recommendations and desires into our consideration when we actually promulgate a final schedule. All right. Now, I'd like to turn to the proposed schedules filed by the other parties and the other 3 dockets. And we'll start with Nutmeg in 250907. If you have your proposed schedule, if you'd like to walk through it, and then if other parties would like to weigh in on their proposed schedules and discuss their particular wishes.
Thank you. Good morning, Chairman Wheel, and good morning, Commissioner Cheeseman and Commissioner Aconti. And it's nice to meet you, Commissioner Beecher and Commissioner Smith. As I stated before, I'm Joni Wedler, and I serve as the Executive Director for Nutmeg TV. And we thank you for the opportunity to speak to you today on the proposed procedural schedule. I am not an attorney, and Nutmeg TV is not represented by legal counsel in these proceedings. As a publicly funded organization, we made a deliberate decision not to allocate public resources towards retaining counsel. Instead, I appear before you directly in my capacity as the organization's chief executive. Before turning to Nutmeg TV's proposed schedule, I want to address a key point that we believe directly affects today's scheduling conference. In every filing, our friends at Optimum, Cox, and Charter insist that these proceedings should examine only Nutmeg TV's plans, budgets, and qualifications, and that Pura's role should be limited to deciding whether Nutmeg TV's proposal alone serves the best interests of the communities and the subscribers. Well, that's a framing tactic, and it conflicts with a statute that requires Pura to evaluate both parties. That evaluation only works if the companies participate as actual contenders and not spectators. Nothing in the statute grants them default control, but says that the authority shall assign the responsibility to the most qualified community-based nonprofit organization or company. This mandates a comparative evaluation, not a one-sided burden on Nutmeg TV. The companies can't simply claim that Nutmeg TV didn't present a plan and then walk away, or as they did, file motions to delay and suspend. And here we are 7 months after the docket began.
Ms. Wedler, I appreciate your comments, and I think they're probably better reserved for when we actually have hearings. I think we're here today for a scheduling conference.
We are.
And Mr. Bumpin has advised me that we do have every party's scheduling conference available. If you'd like to post it on, we could share it with the rest of the room.
I appreciate that, Commissioner Cheeseman, but these comments that I am making, as this is not an evidentiary hearing, are directly important to why we have the proposed schedule that we have.
All right, understood.
Thank you. And I understand what you're saying.
Would you like Mr. Bumpin to put your proposed schedule up on the screens for everyone to see? Or
If they don't have them in front of them, they certainly can.
would it
Certainly
be
can.
useful for the parties to have them up? I know what it would be useful for me.
Yeah, I'd like that.
Yeah, so.
The incumbents have no presumption of retaining PEG operations. They must present evidence on the same criteria that Nutmeg TV is presenting. We thank Pura for the order to compel. The responses from the companies to ensure that necessary data is in the record for comparison. It's the only way to evaluate both parties. Now that the companies have finally submitted the requested data, Nutmeg TV can fulfill its obligations by providing a budget. financial conditions, debt agreements, and related obligations in the petitioned areas, Nutmeg TV had no way to responsibly provide financial projections. Turning now to the proposed procedural schedule, it's prompt, but reasonable for two reasons. Companies have already stated in Pura dockets that they are not opposed to transferring responsibility for PEG operations in any community to a qualified third-party nonprofit like Nutmeg TV. And it's worthwhile, they say, to simplify and streamline that process. We agree. Secondly, Optimum went one step further in this proceeding and filed correspondence that it fully supports, and I quote, consolidating current PEG operations and facilities among larger areas of Connecticut, not tied to the traditional franchise service areas, and transferring all remaining PEG operations to independent PEG operators with a reconceived model for community access. We agree, and that is what our petitions are doing. Excuse me.
So Ms. Whether you would propose a consolidated schedule covering all the dockets and in this
Yes.
particular schedule? Okay.
Yes,
I just want to make sure. I'm clear.
yes.
And other commissioners, please weigh in if you have questions.
The second reason our schedule is prompt is that a docket like this doesn't have the same level of record that the Cox Charter merger had, which took 8 months to connect the largest cable and broadband providers in Connecticut. Proposed schedules calling for 13 months to transfer PEG access from companies that claim to support a transition to a petitioner like Nutmeg TV with over 35 years of experience simply doesn't make sense. As I said earlier, Nutmeg TV we are now in month 7. We were very aggressive upon filing in 2025. Nutmeg TV invited Cox, Charter, and Optimum each for a facility tour and discussion. All declined. By September 25th, the companies filed for a stay to learn about Nutmeg TV was doing, but none reached out to us. Nutmeg TV supported the stay with a filing to Pura, with the presumption that good faith discussions would follow. In October, having heard nothing, Nutmeg TV scheduled virtual meetings with each company, inviting engagement before a more formal Pura process. We answered all their questions. We sent them written questions to clarify discrepancies we found in their annual reports. We offered non-disclosure agreements. We offered our vision document, our plan. None of the three, Optimum, Cox, or Charter, followed through after the initial meeting. December and November came and went. Nutmeg TV filed status reports with the authority. No engagement from the companies. January ended the stay. Charter requested an informal meeting, which we went to. It was a great meeting. They asked for an NDA. We provided it with no further communication, despite repeated attempts. Nutmeg TV filed our interrogatories on February 1st. They were due on the 17th. The companies moved to suspend, and no interrogatory responses were submitted. February 19th, Nutmeg moved Pura to compel. February 20th, Optimum sought an extension. We see an underlying theme here, and that's non-engagement. The pattern is clear. Repeated delays, refusal to engage, and disregard for the process do nothing to advance public interest. If the companies wish to continue as community access providers, they must meet their burden and show why they are better suited than Nutmeg TV. With the interrogatory responses finally submitted, Pura can proceed with the careful, transparent evaluation this proceeding has always required. We urge the adoption of our proposed schedule, given the reasons that I've just gone over. And I'm happy to answer any questions.
All right, thank you, Ms. Whitler. I think that your schedule and the explanations you've given are clear. I invite commissioners if they have any questions. All right, comments from the other parties? The OCC want to start, and then I'll turn to the other companies.
Thank you, Commissioner. As we outlined in our proposed schedule, we believe that for the efficiency of, sorry. As we proposed and outlined in our schedule, we at OCC believe that this docket would be efficiently heard and judiciously given attention, and also for the interest of consumers if it's broken out into respective dockets. From our docket outline, you could see that we are proposing dates that run from April 23rd all the way through August 12th. And we believe by doing so, it allows all parties to be able to go and review the interrogatories and the materials that will be exchanged in an efficient manner, and will also give our staff the necessary time and resources necessary to be able to do so.
So that's why you would like a different schedule for each docket, despite the requests of, I think the other parties would be happy to see everything running on the same schedule.
I believe every party here wants these dockets to be given significant attention, and I believe by splitting them up into respective dockets, we'll be able to do justice to same.
All
Rather
right.
than lumping everything up and extending the timeline to, I believe, September, as the companies are proposing in their respective schedule.
All right. Do you want to put your proposed schedule have Mr. Bumpin put your proposed schedule up on this, or do you not feel that's necessary?
So we have a different one for each docket, so we could
Yes,
put up the one for this 07.
this is
09,
250907.
09.
Excuse me, for OCC, are you envisioning sequential or concurrent for the separate dockets?
Concurrent.
So
with
it all
the-
gets done within that time frame.
Yes.
Thank you.
All right. Do the companies wish to comment on this proposed schedule, or do you want to reserve your comments till we get to the end of all the dockets, or do you not wish to comment at all?
So good morning, Chairman and Commissioners. I think we can reserve until we are going over our own schedule. I mean, I think we're going to see the patterns and differences between all three proposed schedules. So I just think for efficiency's sake, it makes sense to hold off.
Move through and hold off?
Yeah.
All right. That sounds good. All right. Next, moving to 250908. Again, your nutmeg schedule stays the same. 250908, again, I believe OCC, you have a different schedule for this one, correct?
No, we do.
All right, would you like that to be put up?
Sorry, not to confuse everybody, but I had a question for OCC going back to the 07 schedule, 250907. I didn't see a hearing. I heard that the idea of that schedule was, I think sounds like everyone's hopeful that MOU process will go through, but my understanding was the proposal was to have a schedule in case it doesn't, but I didn't see, look like that. There's an end of discovery period and briefs, but I didn't see any evidentiary hearing in that proposed schedule. Was that intentional?
So I believe,
Over 10.
sorry, the Comcast docket?
250910 is the, not 7. I apologize.
1 second. So there should be an evidentiary hearing, so that would be another point of clarification that we would urge the authority to take note of. Thanks.
I'm thinking maybe could OCC just file as correspondence, just an update, because this is also the one where there was the typo for the June, July. Just file an updated schedule that has the hearing and corrects that month. Thank you. And again, sorry for everyone to
We'll do so.
confuse
Thank you.
going back 3 places from where we actually are in this hearing. Thank you.
Yep, sorry.
Excuse me one sec. Back to OCC. I apologize if I missed this, but could you just summarize for me why you want separate but concurrent proceedings?
So as we outlined, we believe that it would be in the interest of consumers since we are asking, and this goes back to what Nutmeg mentioned earlier during their statement, which is the companies are asking that we limit the scope to reviewing only Nutmeg's petition as it pertains to this docket. But we are of the view that in being able to assess and efficiently analyze their ability to take over operations, that means that we need to understand the existing metrics that they are using in the operations within their own service areas. So that would require, as it can be indicated in our interrogatories, also reviewing their operations, their financial statements as well, and things that were requested in our respective interrogatories to the video providers today. And that would mean going through every evidence and every interrogatory that has been issued. And with that, we are of the view that that requires time and judiciously advocating in each respective docket rather than lumping everything together so that all parties have time to be able to review what is on the record.
All right, and I believe the final docket is your proposal 250909. Again, do you wish to have further discussion on that and have Mr. Bumpin put that up on the screen for us?
So similar to the same sentiments we just echoed, we do believe that this schedule is reflective of our stance on how these dockets should be broken up respectively. Also, if we look at the timeline, it's within the same scope that the company's already proposing, so it's not outside. I believe the only significant difference is that we are proposing a shorter time frame as to the extension of the company's proposed schedule that I believe goes to September 12th or the 17th, I believe.
All right, thank you. All right, and I believe,
Sorry, may I ask
Sorry,
just a
sorry,
quick question on the,
sure.
so is the major difference between the proposed schedules for the 3 other companies, is it the having 3 separate hearing dates and sort of having specific timing for each hearing to be separate?
And briefing,
Okay, and briefing, separate briefing.
yes.
Okay, understood. Thank you.
All right, and I believe Optimum, Cox, and Charger have a joint proposal for 07, 09, 08, and 09, is that correct? All right, do you wish that schedule to be put up and,
Yes, please.
all right. Do you have that? Mr. Bumpin?
So as a preliminary matter, we take the position that the 3 or each of the petitions could be merged into a single proceeding. And it's hard for us to envision how the discovery and the record would be developed and the decisions be made without considering what's happening in each other docket and each other proceeding. Nutmeg's plans in one area will impact other areas. Their vision document that they put forth discusses efficiencies to be achieved through regional operation and consolidation of resources across several areas. So it's hard for us to just wrap our heads around how one review of one petition would not impact reviews of the other petitions. Additionally, as I said, it doesn't seem that PURA can decide these in a vacuum without considering its own deliberations in the other proceedings. And And then just as a third point, we would like the authority, and we are conscious of the authority's time and resources and our company's resources. And we think that combining the proceedings would lead to the most efficient use of resources. Anything else on that point?
Meg, do you wish to comment? Do you have any further comments, Attorney Bogan, or any of the other parties?
But I'm being deferential.
Thank you.
We do have a comment. In our procedural proposed schedule, we are specifically asking for different hearing dates for the different dockets for precisely what you said, Attorney Bester. Each area is very different in how it conducts business, and so we think that because of those differences, there's many similarities across the spectrum of these petitions, but those are very different. And technically, from a technical operations standpoint, Chris, would you like to add anything?
Certainly. Again, as per the vision document, a lot of the interconnectivities between regions will be managed in one central location. So from a technical standpoint, especially in today's day and age, sending signals throughout the state is as easy as changing an IP address or maybe putting in a small box here or there. There's not much to it. We'd have to discuss that with engineers, of course, to make sure that things are okay. But in terms of regionalization of these areas, outside of a studio space, there's not too much to it. And that's why we believe that in this type of schedule, each an individual area should be handled with care, and then, but in the timeline that we have put forward.
Would Office of Consumer Counsel like to weigh in?
So in light of the schedule that is being put forth by Nutmeg and the video providers, the OCC is open to considering a schedule with the timeline being shortened. So if it's within the boundaries of the same, I believe the July track timeline that we are proposing, we're open to consolidating the respective dockets. But we would urge against September dates, just because we do have a lot of dockets and a lot of hearings coming up, and we don't want to be stretched thin. But we are open to just compromising on consolidating some aspects of the schedule, with particular attention being given to hopefully not extending that towards a September deadline for the final decision as it's being proposed by the video providers.
Well, obviously, the commissioners are all cognizant of how much everybody has on his or her plate. So anything we can do to, with due process accorded to the parties to accomplish this in a timely and efficient manner will be viewed favorably, if I can say so.
Thank you, Commissioner.
May I be heard?
Yes, you may,
Better with the mic on.
Attorney Bogan.
Thank you very much, Commissioner. And first of all, Commissioner Smith, welcome. I haven't had the pleasure of appearing before you yet. I want to level set. And first of all, let me correct the statement. I believe Ms. Wedler said that the video operators wanted to limit the scope of this proceeding to a review of the nutmeg proposal. That's not the case at all. What the video operators have suggested is that in the first instance, we should be looking at the nutmeg proposal. I say that with some measure of hesitation because I know the old adage of the definition of insanity is doing the same thing over and over again and expecting a different result. And this is the same argument that we've been making since January. But, you know, the only instance where I can recall where we had a similar circumstance was in 2005 or so when Southeastern Connecticut TV petitioned to take over community access operations in the Groton franchise area. In that instance, It was a Comcast franchise area. It was operated by Frank Ficini, who was Comcast's public access manager. So to some extent, it made sense that Frank might be appropriate. I will note that in the first instance, I think the docket was 050610. You can go and look because maybe I missed it. I lived through it. How many interrogatories did the authority's predecessor, the Department of Public Utility Control, issue to Comcast? 0. How many interrogatories did the Office of Consumer Counsel issue to Comcast? 0. Why? Because the focus was on Frank Ficini and Southeastern Connecticut TV's plan. And so what we are saying is that in the first instance, you have to look at the plan. And only if you determine that the plan has credibility, viability, then it's appropriate to compare it to the status quo. Now, Mr. Bumpkin, can you put up the map, if you would? Thank you. Now, this is a map from the authority's website. In the Southeast Connecticut TV docket, it was a single franchise area that was sought to be controlled and operated by SCC TV. In this proposal, we have Nutmeg TV, and again, this is not a commentary at this point on Nutmeg TV and their ability to run PEG, but just to give some perspective. What Nutmeg currently operates is the piece right in the middle. I think it's number 18, that blue segment. That is roughly 8 towns, 237 communities. What Nutmeg is proposing is what's outlined in the black lines. That becomes 55 communities, total of 8 studios, and over 1.3 million customers. This is profoundly different from the Southeastern Connecticut TV proposal. That's why we're not looking to be dilatory. We're not looking to pass dispersion with regard to Nutmeg. We're just trying to have the authority and everyone realize the magnitude of this change. There has never been anything like this in the state of Connecticut. And so that's why we have been saying, well, wait a minute, time out. Before we jump into this pool, can we see what the plan is? Can we see budget projections? Can we see personnel projections? Can we see funding projections? Can we see how regionalization, as has been said this morning, is going to happen? We now have some glimpse into what it is because Nutmeg alludes to maybe needing another employee, maybe shedding some studios, but we don't know that. A vision statement, which was nice to be able to finally get it, is not a business plan. And so that's what we're looking for. And that's why our schedule says we need to see the business plan because we are in no position, nor with all due respect, do we believe the authority is in any position to evaluate until we see the business plan.
And thank you for tying that into the schedule at the end, Attorney Bogan, because I think we might have been, as I mentioned to Ms. Wheeler, straying a bit far from the purpose of the scheduling conference. But obviously, this is an issue that is of, as you indicated, of much more scale than the prior proposal. And I live in Southeastern Connecticut, so I remember things going on. And obviously, things that this authority will take into account. Do you have any further comments with regard to your proposed schedule?
Only with regard to that is what influenced our schedule and proposal. We're in a position to file pre-file testimony because we're shooting in the dark. We don't know what we're supposed to be attesting to.
All right, thank you. I believe Ms. Wedler has something to say.
Thank you, Commissioner.
Thank you, Attorney Bogan.
I'll remind you, Attorney Bogan, that SCCTV's docket was over 2 years, and we certainly don't want to redo that. I'll also mention that we've been thinking about this for 2 years in our conversation with Governor Lamont. who said, you know, if you would put that map back up, Robin, consolidation works. I mean, we've got areas on that map that have the doors closed and the lights off, and money is still being collected from subscribers to run that. And that's been going on for years. So it was our discussion with both Senator Needleman and the governor about reducing and consolidating those areas. So there is no increase to subscribers, no extra expense for the companies, but taking a tried and true regional operation and having it work in those areas, even with satellite locations. So that's what we're choosing to do. And really, having met with the companies and read what they've had to say, it appeared to us that the companies really did want to divest themselves of these responsibilities. This is not their core mission. It's ours. We're an independent nonprofit. We have to go through regulatory filings that nonprofits have to go through in Connecticut. We have a lot of transparency. And when we read the company statements, which is why I read them, and I'm sorry, I was nervous when I read them, so maybe they didn't come out as well as they could have. But the bottom line is the record states that if a nonprofit that was qualified came forward, you would be open to that divestiture. And we threw our hat in the ring. And we're delighted that Comcast has taken the position that it has to remove a burden on the authority for us to arrive at an end result that benefits both the company and the public.
All right. Thank you. I think we're clear where everybody stands on this, and obviously everyone will be afforded an opportunity to discuss this in more detail for the authority to render a decision. Attorney Bester, did you want to weigh in here?
Yes, please. Thank you. I just had a few more comments on the schedule. I think the major difference between our schedule and the proposed schedule by the OCC is the length of discovery. As we just discussed, we believe there needs to be robust discovery, which is going to include numerous rounds of interrogatories, which frankly, we just haven't put together yet. And so in order to do this, we now have a plan or a vision statement to review and direct the appropriate discovery to understand exactly what Nutmeg's proposals are. So we believe just like the potential for 2 rounds of questions and answers at the bare minimum, you know, a month, 5 weeks, I think is what we've proposed. And then just to correct one quick thing that Nutmeg stated is that the lights are off in certain areas. And this is a factual statement, but the lights aren't off. Studios are available upon appointment. There is a fundamental difference in how some of these areas are operated by different companies. And so just want to point out that, at the end of the day, it's what the communities want. It's whether there is buy-in from the communities, because at the end of the day, this really is funded by subscribers. And, those subscribers need to understand in the record whether, their per subscriber fees are going to increase. And, we just don't have that information yet.
Thank you.
Can I ask a little lost on the scheduling point. Your proposed schedule has end of rolling discovery in like 2.5 months from now, right? June 16th, with an evidentiary hearing literally 3 months from today. So I didn't understand the reference to a month of discovery.
I think that was before testimony is due. So we need to understand, before submitting pre-filed testimony.
If I may, Chairman Wheel, I don't think we're wed to the date. I think it was simply affording latitude to engage in discovery. I'm flexible on, when discovery ends, as long as there's a suitable period for discovery and leaving ample time for the provision of pre-filed testimony. But I think what we were trying to reflect is giving, I don't think we're going to file pre-filed testimony. Okay. I think we're consistent with what I said before, would be filing reactive testimony. So we would be filing rebuttal testimony. So we were simply trying to be cognizant of the fact that Nutmeg, who, as Ms. Wedler said, is not represented by counsel, would need to prepare pre-filed testimony. So we were simply giving them 6 weeks to do that. If they think they can do that in a shorter period of time, that is certainly fine by us. We would then need a suitable period of time to file rebuttal testimony, presumably like 2 weeks or something like that. At that point, we can then talk about a hearing schedule. And that reminds me of one other thing that was discussed earlier. I don't know if it was with Ms. Wedler or OCC or both. I kind of see the schedule as like a rate case where you may have cost of capital witnesses, you have rate design witnesses, et cetera. So we can have a consolidated proceeding on all dockets, but we may say on Monday, it's focused on the Cox franchise, et cetera. So we're not wed to those dates, but that's kind of the method to the madness in proposing them.
I did have a similar thought. I must admit that it does seem possible to have a consolidated hearing where we address multiple different perspectives, and we do that all the time in rate cases, as you just pointed out. Like we can have a hearing where it isn't just a single panel talking about a single thing, and that's it. Well, I just want to throw out there, trying to borrow some of the vice chair's energy of encouraging everyone to just come together and make our jobs easier. I'm looking at the company's proposed schedule as a final decision, September 30th. OCC's July 31st. We've heard that it's very important for OCC to not push this out all the way out as far as proposed by the company. But I'm also observing, so there's a 2-month difference between those dates, but I'm also observing the company's got an evidentiary hearing on June 30th. OCC's got a late file hearing May 11th. Suddenly we're a little closer. I guess what I'm getting at is it feels like there might be a way to kind of meet in the middle somewhere with respect to like when we're done with a hearing, and then maybe the dates after that might be easier to kind of collaborate on in terms of how much time is necessary post-hearing. And maybe that's just the way I just tend to always view these things as you need enough time to get ready for and conduct the hearing, and then after that, everyone's got to write their briefs, and then we have to have our time period to receive the briefs, obviously, afterwards. But anyway, just kind of throwing out there that maybe there's some room for folks to kind of compare notes as to the idea of a singular schedule that gives enough time total for OCC to cover all the things OCC needs to cover. Because that was also going to be my response to OCC is I hear you, believe me, I hear you, but I feel like it might, and I'm glad that you folks had the thought of maybe a consolidated schedule could work, because I think it seems to me that as long as there's enough total time for OCC to be able to do the total amount of work it needs to do, it can kind of internally manage its schedule to kind of cover the pieces between now and the sort of ultimate end game. Does that make sense to you?
That makes sense. We were actually going to follow up on happy to hear that you're not bound to the dates you provided, because our question was going to be between the evidentiary hearing and the initial brief due. It seems like there's a whole month between those two items, and we're happy to work on a compromise that shortens the dates if at the authority's discretion they find that needful.
So if I may, Mr. Chairman, at the risk of speaking when I haven't consulted with Mr. Bester, consistent with your suggestion, we could split the difference. I think we can live with an August decision. What we can't live with all due respect to the OCC, is pre-filed testimony on April 27th. That's too soon. And a hearing on April 29th. That just is impractical. So we would have to, I think in the first instance, and I'm not looking to develop this schedule right now, perhaps before the authority does anything, we can talk offline, and get an understanding. If Nutmeg is willing to file their business plan, then everything can flow from that. Because once we have that, we're in a position to move forward.
Nutmeg's pre-filed testimony is going to be filed within the next 2 weeks, so we don't need that 6 weeks.
And sorry, Ms. Whitler, that would include the elements that the other companies request, a business plan, the necessary information for them to submit their questions and for OCC to be able to submit, and Pura staff to submit interrogatories.
You have to realize that we have a board of directors, and our leadership cannot make decisions that are detailed decisions until we have the data from the companies. And the data came in from the companies on the 26th, I think, that was their last filing. And so now we can take that information, because you're right, Attorney Bogan, when you look at the map, one area does affect the other areas. I'll also bring to mind that Comcast's MOU will be done by April 30th, which is why we suggested that that is done around the hearing date, because if those talks were to fail for some reason, there's time for Comcast to jump back in. But we don't anticipate that. Things are going very well with Comcast, and Comcast is a good leader here, but the areas will all be impacted, right? If there's one regional TV branch that's going to serve people in a larger area, it would affect the other companies, certainly. And as companies operating under certificates of video service, they'll be interconnecting. So there's a lot of things to consider, but that's our pre-filed testimony will include that, and that's coming in a 2-week period of time, including the budgets.
Okay, thank you. Does OCC have any further comments? Parties?
I think, consistent with what I just suggested, if the authority could refrain, say, until the end of the week to allow the parties to.
Right, I was going to suggest if you want to, the parties would like to consult offline as you suggested, and then file correspondence if you have changes or an agreement on what you think would be a proposed schedule going forward. Are we good? Any other comments, suggestions, wishes for chocolate for Easter, anything like that?
I would just add, so if that's possible to get filed by Friday,
Friday's a holiday.
Friday's
Oh.
a holiday, yeah. Oh, we do it Monday?
Monday, we could take, I just, not to be the bad cop, but if we don't see something by Monday, we're just gonna have to do the best we can with the 3 competing proposals we have, and we'll put out the schedule and everyone will just have to live with it. So I encourage everyone to come together and have one more shot at having influence on the outcome.
All right. Well, if there are no further comments, suggestions, I will adjourn this proposed scheduling conference and wish everyone a good week. And we look forward to wonderfully creative and helpful suggestions going forward. Thank you all.
Thank you.